When a judicial nominee can't say whether the president needs Congress before launching strikes, that's not caution. That's the Constitution being quietly rewritten right in front of us. 2.
If you could give me one more moment.
Yeah. We won't take it off your 5 minutes.
Thank you. Thank you, Chairman. Mr. Ganjay, you worked for Professor and former Deputy Assistant Attorney General John Yoo. And I wanted to ask you, he recently wrote an op-ed in the Washington Post concerning the military strikes on shipping and raised an issue as to whether that was lawful. Let me ask you your thoughts as a legal and a constitutional matter. In the absence of congressional authorization to use force, in the absence of any declaration of war, are military attacks on ships suspected of drug trafficking lawful or constitutional?
Senator, I think that's a highly fact-specific situation, and if there were such strikes and there were going to be challenged in court, there is a likelihood that it could come before me if I'm fortunate enough to be confirmed, so I don't think I can offer an opinion on that.
Well, can you offer an opinion on whether you believe that the War Powers Act is constitutional?
Senator, again, that might be something that comes before me as well.
I would imagine any number of legal issues could come before you. That doesn't preclude you from expressing your legal views on the subject, particularly something as broad as the constitutionality of legislation like the War Powers Act.
Senator, my answer is the same.
And let me ask you all, share with me, if you would, your views on nationwide injunctions. And we can go down the line.
I think it's a very developing area of the law after Trump versus Casa and that decision. But typically, injunctions and temporary restraining orders are constrained by Federal Rule of Civil Procedure 65. And the courts have, along with that rule, basically considered 4 important factors as to whether or not an injunction or a temporary restraining order should be issued, which I've already stated. But one of them is the likelihood of a party being successful on that injunction in trial eventually, the balance of equities between issuing the injunction and not, the possibility of irreparable harm, and then, of course, the public interest in issuing that injunction. With it being a developing area of the law, it would be a very cautious analysis, but it would include those factors and the factors enumerated by the court in Trump versus Casa.
So you wouldn't categorically rule out the potential applicability of a nationwide injunction?
I think that we have to examine closely Casa, and the key would be the balance of equities and whether or not that Supreme Court decision constrains the application of those 4 factors with a nationwide injunction, and it would appear on its face that it would. And I think with it being a very developing area of the law, it's going to be a fact-specific and case-specific analysis that goes into those factors.
Care to respond?
Senator, I agree with much of my colleagues' statement. I would say post-Casa, you would look to see what is needed to give the parties before you full and equitable relief, but generally the Supreme Court has cautioned against courts having the ability to bind parties not before it.
And I agree with both of my colleagues, Senator.
If we could go down the line also, do you believe that the Congress has the power to legislate an enforceable code of ethics on the Supreme Court?
I think I would probably need more facts and circumstances to be able to answer that question fully, but certainly if Congress were to pass a law, it would be subject to all the same scrutiny requirements from any other piece of legislation.
Well, can you do a little better than that?
I think that Congress certainly has the authority under the law to issue laws and to vote on laws and to pass statutes, and certainly that would be one that Congress has the authority to do. Whether it would withstand constitutional scrutiny, I would have to have more facts and circumstances to be able to make a complete analysis of that subject.
Senator, I also would like to have more facts before rendering an opinion on that. But I would obviously be very attuned to the separation of powers concerns that something like that would raise.
Senator, again, I agree with my colleagues. I was only going to add the potential separation of powers concern, but Mr. Ganji did that.
Thank you, Mr. Chairman.
Adam Schiff didn't simply ask a nominee a legal question, he held up a mirror to an uncomfortable truth about modern American power. The Constitution is being quietly hollowed out, not by dramatic coups or open defiance, but by decades of silence, hesitation, and carefully scripted non-answers that slowly normalize the erosion of congressional authority. Because listen closely to what happened in this exchange. Schiff wasn't grilling someone about an obscure legal footnote. He was asking about something foundational. Can the President of the United States order military strikes on suspected drug boats, meaning foreign vessels, meaning use of lethal force without Congress authorizing it? And instead of a clear constitutional interpretation, the nominee responds with layers of caution, legal fog, and procedural escape routes. He hides behind fact-specific conditions. He says he can't offer a view because the issue might come before his court. He refuses to articulate even the broadest understanding of what limits the executive branch should operate under. That moment matters because the question Schiff is raising is not a hypothetical. It's not an academic exercise. The United States has a long and increasingly unchallenged history of conducting military operations without congressional authorization. What Schiff is exposing is that nominees, especially for lifetime judicial positions, are being trained to treat basic constitutional boundaries as political minefields rather than legal principles. And that should worry every American, regardless of party, because it signals a government where the branch designed to debate and declare war, Congress, is steadily surrendering that responsibility. Not by vote, not by legislation, but by silence, by passivity, by allowing presidents to act first and justify later. This is a slow drift, a decades-long drift, that most people never see because it never arrives loudly. It arrives in hearings like this one, in nominees who will not say whether Congress has the right to authorize war. It arrives in the form of carefully worded evasions that protect presidential power at the expense of democratic oversight. Think about this. Schiff wasn't asking the nominee to prejudge a case. He was asking whether the War Powers Resolution, a law Congress passed in 1973 to rein in runaway executive authority, is constitutional. That law has governed the balance of military power for half a century. If a nominee can't even say whether the law itself is legitimate, then how can the court ever enforce it? If a nominee can't affirm Congress's role in declaring war, then what remains of Congress's role at all? This is where viewers need to understand the deeper issue. The modern presidency, under both parties, has gradually absorbed the war-making powers of the Republic. Not because Congress openly ceded them, but because no one in power has a political incentive to challenge the status quo. Presidents prefer flexibility. Congress prefers avoiding blame, and judicial nominees prefer saying nothing that might limit a future administration's options. So the real crisis Schiff exposes is a structural one, a constitutional imbalance so normalized that even asking about it is treated as too sensitive for an answer. When nominees fear stating the obvious, that Congress is supposed to authorize war, then the erosion is no longer creeping, it's complete. This is where the public has to stay vigilant because the founders gave Congress war powers for a reason, to prevent exactly the pattern we now accept as routine. A president should not be judge, jury, and executioner on matters of warfare. The decision to use military force should never depend solely on one person's will, whether that president is Trump, Biden, Obama, or anyone else. What Schiff did in that hearing was pull back the curtain and ask whether anyone in government still remembers that. And the silence he got in return was not just one nominee protecting himself. It was the sound of a system that has forgotten its own design. If Americans don't insist on restoring those boundaries, they won't return on their own. Power rarely shrinks voluntarily. And every time a nominee avoids these questions, every time a president launches military action without Congress pushing back, we inch further away from the constitutional framework that was supposed to prevent unilateral executive warfare. This is why hearings like this one matter, not because of the personalities, not because of party politics, but because they expose what has become invisible through repetition. They remind us that constitutional erosion doesn't happen in one moment. It accumulates in 1,000 small evasions. If you're watching this, remember, democracy doesn't collapse only when leaders break the rules. It collapses when the people stop demanding that the rules be followed. That is why we need to stay informed, stay critical, and keep asking the questions nominees won't answer. Because if Congress won't reclaim its authority and nominees won't affirm it, then the responsibility falls on the public to refuse complacency. If you found this breakdown useful, make sure you stay connected with Left Lens, subscribe, share the video, and help amplify real constitutional analysis that cuts deeper than the surface-level talking points. The only way these conversations stay alive is if we keep having them.